$1.4 trillion. Yeah, let that sink in for a second. It's a staggering, almost incomprehensible number, right? Well, that is the amount of outstanding student loan debt in the United States right now. It is literally the second largest form of household debt out there, trailing only behind mortgages. We're talking about a massive financial weight that delays careers, blocks people from building wealth, and disproportionately crushes minority and first-generation college students. But what actually happens when that weight becomes completely, hopelessly unbearable?
Welcome to today's Explainer. I am so excited to guide you through this topic. Today, we're going to decode a really fascinating, sometimes wildly frustrating, and deeply impactful intersection in American law. We are looking at the tangled web between bankruptcy law, the student debt crisis, and health insurance. So let's dive right in and see exactly how a somewhat obscure legal loophole is dictating the financial futures of millions of Americans. Here is our quick roadmap for the breakdown today. First, we're tackling the student debt myth. Second, we'll examine the undue hardship hurdle. Third, we look at the healthcare variable. Fourth, we'll explore how courts are totally split on this. And finally, we'll break down a proposed legal solution. All right, part one, the student debt myth, fact versus fiction.
Our whole explainer today is grounded in this brilliant, comprehensive legal essay called Undue Hardship and Uninsured Americans by Alexander Guzuls. It was published in the Emory Law Journal Online, and it really digs deep into the dark corners of bankruptcy court to show us what struggling borrowers are actually facing out there.
So there is this massive misconception out there that student loans can absolutely never be discharged in bankruptcy, period. But the reality? They technically can be. However, there's a massive catch. Only 0.1% of bankrupt student debtors even attempt to do it. Think about that for a second. Out of all the people driven to total bankruptcy while holding student debt, only a tiny fraction of a single percent even try to get relief. Why? Well, because the process itself is just absolutely brutal. Which brings us to part two, the undue hardship hurdle, essentially a legal obstacle course. Unlike your standard credit card debt or medical bills, which usually get wiped out pretty routinely in bankruptcy, student loans require something called an adversary proceeding. Now, this isn't just checking a box on a form. It's a completely separate, highly formal, and incredibly costly lawsuit. You literally have to sue your creditors while you're already bankrupt, racking up even more legal fees just to beg the court to recognize that repaying your loans would cause you undue hardship. And to actually prove this undue hardship, most courts rely on a super rigid three-part framework called the Brunner test. Step 1. You have to prove you cannot maintain a minimal standard of living if you're forced to repay the loan. Step 2. You must show your dire circumstances are likely to persist for a significant chunk of the repayment period. And step 3. You have to prove you've made good faith efforts to repay the loans already. Now, I know what you're thinking. That sounds somewhat reasonable on paper, right? But how it's actually applied is staggering.
The reality of this test inside a courtroom is incredibly harsh. Judges will frequently demand a literal certainty of hopelessness. For example, in one real case, a court actually faulted a cellist for not taking a night school teaching job. The kicker? There was absolutely no evidence that such a job even existed. In another case, you had a debtor living in deep rural poverty, surviving on just a few $100s a month alongside her 75-year-old mother. She had to fight through multiple, exhausting appeals simply because the student loan corporation used its deep pockets to continuously fight her discharge.
Which leads us to the absolute most pressing question of this entire explainer. If the law says you have to prove you can't maintain a minimal standard of living, where exactly does healthcare fit into that equation? I mean, is health insurance a luxury, or is it a basic human need that's required to simply stay alive? Let's look at part 3, the healthcare variable, and the sheer cost of staying alive. The data here paints a really clear picture. If you go to court and you have no stated medical hardship, the failure rate for getting your student loans discharged is 73%. But if you do have a formally diagnosed medical hardship, that failure rate drops to 48%. So this proves that courts actually do acknowledge medical suffering when it's documented. But here's the catch. What if you aren't currently actively sick, but you just find yourself completely unable to afford basic health insurance? To answer that, we really have to recognize just how unique healthcare actually is. As the late Supreme Court Justice Ruth Bader Ginsburg pointed out in her NFIB concurrence, unlike the market for almost any other product or service, the market for medical care is one in which all individuals inevitably participate. Basically, you can choose to never buy a car, but you cannot choose to never have a medical emergency.
And the financial burden placed on people without insurance is just immense. Even back in 2010, the average individual racked up over $7,000 in health expenses. A single routine hospital stay, that easily tops 10 grand. And we're not just talking about money here. Lacking health insurance is directly linked to increased mortality, severe depressive symptoms, and adverse cardiovascular outcomes. The sheer absence of health care takes a measurable, devastating physical toll on the human body.
Let me ground all this legal jargon in reality for a second with a really striking, frankly heartbreaking anecdote from our source. There was a debtor who owed over $149,000 in student loans. She had zero health or dental insurance, her teeth had literally disintegrated, and she was far too poor to afford replacements or dentures. And yet, her creditors actually fought her in court. They looked a judge in the eye and argued she could still maintain a minimal standard of living and repay her loan. Now, she did ultimately win her discharge, but the mere fact that creditors would seriously argue that someone without teeth is doing just fine, that perfectly captures how brutal this system is.
Moving on to Part 4, How Courts Are Split. It's basically a judicial lottery.
Right now, there is a deep, truly baffling divide across American courtrooms. On one side, you have pro-discharge courts. They logically rule that yes, health insurance is an absolute necessity to maintain a minimal standard of living. But on the flip side, anti-discharge courts explicitly rule that just being uninsured isn't enough to prove an undue hardship. That means if you're a bankrupt student, your entire financial future might completely depend on the personal philosophy of whatever judge happens to be sitting at the bench that specific day.
And honestly, the logic some of these courts use to deny debtors is completely erratic. One court denied an underemployed, uninsured debtor who had serious health issues simply because she was eligible for a hypothetical income contingent repayment plan. In another case, a court looked at a 43-year-old who relied on her parents for food, had a medical condition, and had zero health insurance, but they denied her discharge because she was quote-unquote well-educated and able-bodied. Yet another uninsured debtor with substantial medical bills was denied purely because she couldn't prove her health problems were quote ongoing.
So where does that leave us? That brings us to Part 5, a proposed legal solution and finding some common ground.
Our source makes a really fascinating objective observation here. Despite the massive, constant political battles over the methods of healthcare delivery in this country, there's actually a pretty solid bipartisan consensus on the ultimate goal. Under President Obama, the Affordable Care Act established a mandate for minimum essential coverage. Then, under President Trump, efforts to replace the ACA were accompanied by direct pledges that, quote, we're going to have insurance for everybody. So regardless of political affiliation or the mechanics of how we get there, the federal government fundamentally agrees on one thing. Healthcare is absolutely essential to a minimal standard of living.
Yet despite those reform efforts from both sides, the safety net hasn't caught everyone. A massive 25% of poor non-elderly adults and 24% of near-poor adults are still walking around completely uninsured today. And these are the exact people who are most likely to find themselves sitting in a bankruptcy court, totally crushed by student loans, trying to figure out how to pay for basic medical care.
And as we all know, global crises just act as a catalyst for this kind of suffering. The COVID-19 pandemic placed an unimaginable strain on the U.S. healthcare system. That strain inevitably drives up costs for future consumers and puts basic healthcare entirely out of reach for even more struggling Americans. It just exponentially increases the urgent, desperate need for actual bankruptcy reform.
So tying it all together, the definitive thesis we can take away from our source today is this. Any student loan debtor without access to basic healthcare necessarily suffers an undue hardship. Therefore, they must be entitled to a discharge of their student loans in bankruptcy. If you literally cannot afford to keep your physical body healthy, you absolutely shouldn't be forced by the state to pay a corporate creditor first.
I want to leave you with this final provocative thought to chew on. If the federal government, across both sides of the aisle, agrees that healthcare is a basic, vital necessity for survival, why does our bankruptcy system still actively punish students for treating it like one? It is a glaring legal contradiction, and it has devastating real-world consequences for real people. Thank you so much for joining me on this deep dive. Keep questioning the systems around you, and I will see you next time on The Explainer.